So today we are going to do mostly discussion of the Arrow case and the little slip and fall fact pattern. And we're going to focus on ideas like jurisdiction, the litigation process, discovery, things like that. Hopefully we'll put those a little bit into practice. Before we do that, I'm going to pass around a couple books that I told you I would from, I think, Unit 1, and they've been in the back of my car for 3 weeks. The first is a volume of the Georgia Code. These are statutes, right? So they would be passed by the Georgia legislature. These books are divided up by subject matter. So I've grabbed crimes and offenses. So these are statutes that the legislature has passed that make certain things in Georgia a crime. You're obviously not being tested on it, but if anybody wanted to see what a statute book looks like, these are them. This particular code gives you not only the statute, but it also gives you cases that have interpreted the statute under, and that would be helpful if I was doing research and I see something about discharge of firearms on property of another, and I'm wondering how courts have interpreted or defined certain parts of the statute. Underneath it, they're giving me some cases right there that give me a good start. So I'm not just searching for, sort of blindly searching. All right, the other one is, I told you that case law, decisions by courts are written, published, and kept in volumes by year. So I brought you a volume of cases from the Georgia Supreme Court from 1854. So these are all still good law unless the legislature has changed the law since the case came out, or unless courts have interpreted these cases differently and overturned precedent. Probably not many of these would be relevant to anything today, but it's certainly possible that they could be. So not being tested on this, you don't hurt my feelings if you don't even want to look at it, but I'm going to pass it around in case you do. All right, let's go to the Arrow case first then. This is a real case. It was decided by what court? Who decided this case? Say it again, Ms. Mills. Court of Appeals from where? Georgia Court of Appeals, right. Is that a trial court or an appellate court? It's an appellate court, that's right. So this court did not hear witnesses and testimony and see evidence. They just took the transcript of what happened at the lower court, and that was what they used to determine what the facts of the case were. All right, so good. Who's the plaintiff in this case? Who did the suing? Say it louder. Gordon Greaves. Good. Who is he, Ms. Hernandez? He's a Georgia resident. Who's the defendant? Arrow Toy Store. What do we know about Arrow? All right, they're a Florida corporation. So if I'm diagramming this case, it is Greaves versus Arrow. And what was the trial court, by the way? Did anybody pick that up? State Court of Cobb County. Good. That's in the Georgia State Court system. So Greaves is probably a resident of Cobb County, and he wanted to sue Arrow, and he thought, well, I'm going to sue them where I live. Okay, I don't want to go to Florida to chase after these turkeys. I want to sue them here. So he brought suit in the State Court of Cobb County. Did they even get to a trial in this case? Did the State Court of Cobb County rule for Greaves or Arrow based on the merits of the case? No, because Arrow did something before it even got to trial. What was that? Yeah, they raised their hand and said, excuse me, Judge, this court does not have jurisdiction over us. And what was their argument for why the court did not have jurisdiction over them? Louder, Ms. Weatherly? All right, that's one thing. No physical presence in Georgia. All right, inadequate contacts with Georgia. That tells us, well, let me ask you a different way. If we know that Arrow is a Florida company that doesn't have any employees, agents, offices, or anything here, how is it, what law is Gordon Greaves using to tell the court that they do have jurisdiction over somebody from Florida? What do we call that statute? The long arm statute. Good. And the long arm statute, as we know, says courts of one state can have jurisdiction over somebody from another state if they have enough minimum contacts with that state such that it would be fair for them to be sued there. So, what happened between Greaves and Arrow? Who can tell me what is Greaves' beef with Arrow? Chappie, what's the beef with Arrow? Yeah. Oh, I didn't call you by your right name, so I understand. Mr. Chapman. All right. That's his beef. He bought a car, and once he got it, then what? What do you think Arrow did about some of the facts about the car? That they misrepresented them, they kind of lied about them. Good. All right. Green, how did he buy the car? eBay. She saved you. That's all right. There's two Greens. My bad. Ms. Green, you did it. I got you on the hook now. Where did he buy it? All right. And has anybody ever bought a car on eBay Motors? I have not. No one? Y'all bought something on eBay before? Okay, most people have done that. All right. Or bought something off an online auction site. So what was the interaction between Arrow and Greaves, Ms. Green, leading up to the purchase of the car? They were chatting, right? They were chatting through what? Email, right? How was Greaves able to contact Arrow? Right? The eBay Motors platform has a button, contact the seller, ask questions, that kind of thing. So this was not a situation where Greaves just typed in a bid and hit place bid. He reached out. What did he ask Arrow about the car? What were some of the interactions between them? Mr. Garcia, what were some of them? Yeah, he was asking about the warranty. Good. What else? Mr. Cruz, what were some of the other interactions? Anybody? Spalding, what were some of the other interactions? I told you I was going to call on you. Ms. Hackett, what were some of the other interactions? Anybody? What else? Purchase agreement. Good. That got faxed back and forth, right? Greaves asked a lot of questions, gathering information so that he could calculate his bid. He entered the bid, ended up winning the car. How did the car get to Georgia? Say it louder, Ms. Hernandez. Delivered. Were you not the one that answered that? Oh, I'm sorry. I'm old and I can't hear. I apologize for keep asking y'all to speak up, but I cannot hear anymore. Arrow delivered it into Georgia, right? Greaves got it, and I think y'all identified correctly. He decided once he got it that Arrow had misrepresented some things. He wasn't happy with the purchase, and so he sued Arrow Toy Store for it. Could he have gone to Florida and sued Arrow? Sure, right? Because that court definitely has jurisdiction over Arrow, and Greaves can go and submit himself to another state's jurisdiction if he wants to, so long as they have jurisdiction over that defendant. All right, so we had Greaves versus Arrow, and before trial, Arrow filed a motion to dismiss, and the basis of that motion to dismiss was, you don't have jurisdiction over me. All right, when the judge hears that motion, he's going to say, okay, or she's going to say, Arrow, what's your evidence What are the facts that support your position that I don't have jurisdiction over you? So Arrow's lawyers said, okay, Judge, here's the reason you don't. Or here are reasons, plural, you don't. What were some of those? I'm still on the first page. Louder, Mr. Garcia. Only 2 sales, okay. 1% of their total revenue for the year or something like, right? 1/2 of 1%. So put that into argument for me.
They have no real contact because it's so minimal.
They're not really doing business in Georgia if a minuscule, this is their argument, right? Only 2.
They're not even licensed to do business.
Not licensed to do business here.
No agents, representatives, officers, or employees in Georgia.
Keep rolling, Topeka. That's right. No officers, employees, agents, all those things. That's basically their argument. So the judge would then turn to Greaves and say, okay, what is your evidence and argument as to why they should be subject to jurisdiction in Georgia? What was Greaves' argument based on the facts here? Or what facts supported Greaves' argument? Say it again. Well, yeah, he's like, well, you say you only sold 2, but there were 11 people from Georgia that made winning bids. What else? How do you respond to the argument that they only made, that the percentage of sales was only 0.5% of 1% or something like that? Doesn't matter because why?
The applicable law says any business.
Okay, any business. Let's stick on the facts for me for a second. If you're Greaves' lawyer, what do you say back to that, Ms. Mills? Okay, good. Those are also good facts. Yeah, they might not physically be here or be licensed here, but they dang sure did business with a Georgia resident, didn't they? Okay. What about specifically the argument that Garcia made on Arrow's behalf that it was a small percentage of their sales? What do you come back on that and say? It's still a percentage of your sales.
Still a sale.
It's still a sale. And how much was the sale for?
Pretty substantial.
Green? Mr. Green. Well, how much? 193,000? Oh, I thought the winning bill was like 30,000.
Well, that's for the 2.
Oh, the 2 sales were 100. Okay, so you're exactly right. So what if it's a small percentage? You made almost 200 grand off people in Georgia. Who cares what percentage of sales that is? How is that a big deal? Right? So this is what would happen going back and forth. Remember, we hadn't even gotten to trial yet because Arrow's trying to say I shouldn't even be sued here. So the judge in the state court of Cobb County then ruled for who on the motion to dismiss? Did the judge dismiss the case for lack of jurisdiction, or did the judge hold that there was jurisdiction? They held that there was jurisdiction. All right. Arrow gets to call timeout at this point and do what? How did we get from the state court in Cobb County up to the Georgia Court of Appeals? Yeah. Arrow said, hold on, we're going to appeal that decision about jurisdiction. So we're still not going to trial yet. Now the Georgia Court of Appeals is going to take up the issue of the trial court's ruling on jurisdiction. All right, so when this goes to the Court of Appeals, when this case did go to the Court of Appeals, was the Court of Appeals then going to decide whether or not Arrow made misrepresentations or did fraudulent things, or whether Arrow should have to pay damages? No, because that's not what appeals courts do. They're answering what issue? What is the narrow issue that the Georgia Court of Appeals had to decide? Good. Is there jurisdiction? Keep going. Be more specific. In a one-sentence question, is there jurisdiction in Georgia over Arrow based on the long-arm statute? Good. You guys, that is fantastic. All right, so the long-arm statute is a law passed by who? Who writes statutes? Say it again. Yeah, the Georgia legislature. Good, Ms. Hackett. All right, so in one of those books that's being passed around, not that one because that's crimes and offenses, but there is a statute that defines Georgia's long-arm jurisdiction. The court quotes it. Right? The court lays it out for you and says, in Georgia, we can exercise jurisdiction over a non-resident if under certain circumstances. Lays out 3 different ways. Greaves is only asking on the first way here. Greaves is just saying they do business in Georgia, and that under the statute is enough. All right? So, you see that the court is going to lay out the facts of the case. The court's going to lay out what the law is that they're supposed to apply. And then the appeals court is going to see if the trial court correctly applied the law to those facts or made a mistake. Okay? If the appeals court decided that the trial court made a mistake, then what happens? It goes back and the judge is going to dismiss the case for lack of jurisdiction. If the appeals court decides that the state court did make the right decision, then what happens? The case would go back down to the trial court to be tried, or Arrow could appeal one more time to the Georgia Supreme Court. Georgia Supreme Court may or may not hear it. That's exactly right. You guys are tracking right on. The court then takes you through, remember how we talked about the application of precedent, which is cases that have been decided in the past by the same courts that would apply to this one. So the court then takes you through the history of long-arm jurisdiction in Georgia. And the court starts with this Coe and Payne case and says, well, way back in Coe and Payne, and I took the year out of it, and I can't remember what it is to cut down on your reading, but way back in Coe and Payne, we decided that just doing mail order business in Georgia is not enough to establish long-arm jurisdiction. Then the court takes you through subsequent cases where the court kept expanding the idea of long-arm jurisdiction. And they said, okay, well, it was that if you just posted a passive ad and somebody reached out to you and responded and then you shipped the product to them, that wasn't enough. But then we had cases where people were interacting before the sale. And we found that we really need to look at how much interaction there was. And if there was back and forth, if there were negotiations, contacts going each way, then that might be enough to support jurisdiction in some cases. All right? Then we fast forward to business done in the technology era. That's not the right word. On the internet. And the court says the internet, we had to consider cases where sales and business are conducted on the internet, and those old rulings don't really fit anymore. Now, tell me about internet sales. What? It's what? People shop over the internet primarily. It's widespread. People who do business over the internet expect that their customers are going to be from where? Anywhere that has a computer, right? Yeah. Wherever they can be accessed electronically. And so in today's business climate, it is fair to expect people who are doing business virtually and expecting their customers to be in other states to be subject to jurisdiction in those states. So the court shows you how they used to interpret the statute, how it evolved over time, and how they got to where they are now. An interesting case a precedent case that they talked to you about was the Butler case, where the kid in Alabama ordered beer off of a distributor's website. Y'all catch that? Yeah. And even though the kid was able to pull that off by ordering beer off a website that wasn't really a sales website from Illinois or Indiana, got shipped into Alabama, the court did not find jurisdiction there. And did y'all pick up on what was kind of the main piece of evidence that the court relied on there? When we talk about sales and amount, how much would that beer cost? Like $25, right? So the court was like, yeah, you had a website. This kid figured out how to order beer from you off of it, even though it wasn't. If it had been a beer sales website, I don't think we would have had a question, but it was a different kind. And you sent it, and you did send him the beer in Alabama, but it's only $25. So we just, not quite the same as maybe a car that's worth $30,000 or two cars that are worth $183,000. So it distinguished the Butler case a little bit. That is an illustration to you of how courts have to look at the facts of the case, the law that they want to apply, and precedent. And they've got to reconcile and bring all those together to decide what the correct ruling is in this case. What did the Georgia Court of Appeals rule with respect to personal jurisdiction for Arrow? Was it proper in Georgia? Yeah, they did rule that. So our question that we formulated a little while ago was, the question before the court was, is Arrow subject to personal jurisdiction of Georgia under the long arm statute? The court answered that question by saying, yes. All right, that is, I think, a really good example of stuff we've talked about for 3 weeks, kind of how that all weaves together. What questions do you have for me on Arrow? Very much tracks kind of the computer example we were using last week. No questions? Yes, ma'am.
So the person that was selling the car on eBay, were they impersonating like the person that works for Arrow?
They were not impersonating, but because Arrow is not itself a living human, it had its own agent. It'd be like the manager or the sales, somebody at Arrow who was in charge of selling their stuff on the internet. That was legit. There wasn't anything fake about that. Greaves just said, you told me all these things about this car, like the mileage on it or the condition, and when I got it, it wasn't what you said it was.
So if they did find that the long arm jurisdiction didn't count and like Arrow was fine in this case, does the whole case just go away?
Yeah, it's dismissed because a court cannot enter any decisions if it doesn't have jurisdiction over the people in front of it. They have no power over people that they do not have jurisdiction over. So if the court had found that the trial court erred, made a mistake by finding long arm jurisdiction, it would go back down to the trial court and they'd dismiss it. Now I left out a possible outcome. If the if the appeals court did find that the trial court made a mistake, Greaves could have done what? He could have gone to Florida. But what about, is he still alive in Georgia in any way? He could appeal to the Supreme Court. The loser can still appeal. So he might have had another chance to get the Supreme Court of Georgia to say the Court of Appeals was wrong and the trial court was correct.
Does the Supreme Court have any time limit on, like, say, Arrow appealed it up there?
Yes, there is a time limit, and courts are organized by term, which are time periods. And if a case is appealed to them within a certain term and they accept it, they have to issue a decision by the end of that term. Terms are shorter than a year, but they could be 9, 10 months. I mean, it ain't quick. Yeah, I mean, think about it from Greaves's perspective, from a practical perspective. He had to wait on the Court of Appeals to rule. And then if it went against him and he appealed, then he has to wait on the Georgia Court of Appeals to rule. And if that happens, we're probably 2 years into the case. He's still got a lemon car. Arrow's still got his money. And if he loses his jurisdiction appeal, then he's got to go sue him in Florida, like Ms. Weatherly said. Greaves has no recourse. After 2 years, he's still stuck with the car. So he could have gone to Florida and short-circuited the whole jurisdiction issue. But the trade-off is he would have had to hire a lawyer in Florida and travel to Florida and put himself in front of a Florida court. These are all decisions that lawyers would hopefully have given him good advice on and helped him make. I love the way y'all are looking at this. All right. We don't have much time, which is fine. So I'm going to short circuit a little bit the slip and fall case. Go ahead and pull it up. It says for discussion 2.5. Does anybody not see that? All right, I want you to read the fact pattern. It's maybe 2 paragraphs. Don't go any farther than just the facts. I'm going to do this actually for our people online. It's probably easier for me just to read it. Fresh Mart is a grocery store in Columbus, Georgia. On a busy Sunday afternoon, an employee mops up spilled olive oil in aisle 3. A caution sign is placed at one end of the aisle, but not the other. 15 minutes later, Mary Johnson, a small business owner, enters from the unmarked end, slips and falls, fractures her wrist, sprains her ankle. She incurs $18,000 in medical bills. She loses about $12,000 in profits because she can't run her flower shop during prom season. She sues Fresh Mart for negligence, asking for $50,000, and that number would be her medical cost, her lost income, and some money for pain and suffering. What I want to focus on here is the issue of discovery. So 3 methods of discovery that we discussed this week: depositions, interrogatories, requests for production of documents. What are some of the interrogatories, written questions that have to be answered under oath? What are some of the interrogatories that Fresh Mart wants to ask Mary? Y'all are all Fresh Mart's lawyers. What do you want to ask her? She's asking for $50,000 from you for medical bills, lost profits, pain and suffering. What do you want to ask her to start with? Did you or did you not see a caution sign? Good. What doctors did you go see? Excellent. All right, we got to get to the bottom of this $18,000 number, right? Is she padding that, or is that a decent number? Why is that important? Because if it's a decent number and I'm Fresh Mart, I might want to offer her some money, make it go away, right? All right, what else are we asking her? Yes, Chappie, why? Right, he said for those online, he wants to see her tax returns for prior years. You say you lost $12,000. That's fine for you to say that, but I need to see the proof of that. Good. What else? Hey, Mary, have you ever done what before? Sued anybody else for slip and fall? How old are you? What other ailments do you have? What other diagnoses do you have? What medicine do you take? Do you use illegal drugs? What medicine did you take on the day you fell? It was a Sunday. What did you do the night before? Had you had any alcohol? Were you high? Right? All these basic questions. If you're Mary's lawyers, what do you want to ask in your interrogatories to Fresh Mart? Louder, Mr. Hernandez. Yeah, why wasn't there? Explain to me why there wasn't a sign at the other end. Have you been sued before? What's your store's policy on spills? How many signs are supposed to be put out and where are they supposed to be put out? Because if you've got a written policy that says we put a sign at each end of the aisle where there's a spill, that's pretty good evidence for Mary, isn't it? You can show that they didn't even follow their own policy. Yes. Yep, you're good. How'd they prove she was lying? That she didn't actually fall at all? No, on the interrogatory, they asked. Oh, well, so, okay, I see. Say she lies and says, I had not had anything to drink. In Fresh Mart's discovery, they might take depositions of her husband or her kid, or something else might come up that might clue them into other evidence that they can find. Maybe they find out that she was at a party that night. Maybe they take her deposition later and say, you said you weren't drunk Sunday. Tell me again what you did Saturday night. I don't remember. Or I went out. Where'd you go out? How much did you have to drink? Da, 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 da. They might want to ask for her credit card statements because it might have a charge from Mr. B's liquor store where Mary bought 3 things of tequila. They've got to figure it out. So if they want to catch her lying, they got to have some evidence, but they keep on looking. That's a great question, right? You don't have to just take her word for it. People lie. Y'all know people lie, right? I mean, people lie as easy as they breathe. So you got the interrogatories that you would be asking basic stuff. You could sit her down for a deposition. If you're Mary's lawyers, you probably want to take a deposition of who do you want to depose from Freshmart? Who do you want to sit down in person in front of you to have your lawyer question them? The manager. What else? The employee who cleaned that spill up. What'd your manager say? How long was it? How'd you find out there was a spill? Tell me exactly what you did from the time you found out there was a spill to the time that you cleaned it up or whatever. Why didn't you put out 2 signs? How many spills do you get? How many spills have you cleaned up? Do you always put out 2 signs or do you sometimes put out 2 signs? Who did you ask about this? Who else saw what you did? All right, that's a question for Mary. What other witnesses do you have that are going to say that they have any knowledge of this? People in the store, your family members, your doctors. When it comes to document requests, if you are Mary's lawyers, what documents do you want from Freshmart? Procedure, yeah, your policy manual, good. Good, Spalding, previous accident reports. Let's see if you say that you follow policy. Well, let's see if you really do. Good. If you're Freshmart's lawyers, what documents do you want from Mary? Kenneth already said a good one, your tax returns. Hospital records, yeah, show me the bills. Phone records, yeah.
Some sort of proof that a wrist fracture or a sprained ankle would make it to where she would lose the total amount of $12,000 in profit.
All right, that's a great question.
Could she not do some work?
So, that's probably a better question for what kind of discovery other than a document request. Explain to me how your wrist and your ankle kept you from operating your business. That's a question for what kind of discovery? The deposition, the in-person back and forth, right? If I put that in an interrogatory, she might just write back, I was unable to get out of bed, I was incapacitated. She answered my question.
You would need to have, I guess I jumped the gun a little bit in my head. I'm thinking about you would need some sort of medical proof, a written note from someone.
Okay, so you're right on. The document request would be any document that says you can't work or that shows you were unable to work or use your hand or you're asking for her proof.
Yeah.
When we're in person, we can ask her what her reason is to give me orally. But when I want that document request, I want to see if she has anything that supports what she's saying.
Because that should be within her medical release file.
So you're exactly right on. You and Chapman are good lawyers for Freshmart. Y'all are all over this lady. No, it could be Freshmart's fault. I'm not dogging on Miss Jackson. Yes. Yep. Okay. So part of the facts is later on down, Freshmart, part of their defense is she was distracted. So yeah, maybe we were negligent a little bit, but she was also negligent because she wasn't paying attention. How would you prove that? Yeah.
She put
You could pull the cameras. That would be great evidence, wouldn't it?
Security feed, witnesses. Yeah, any damage to the phone?
Yeah. I mean, I wonder if you could pull, I don't know this, but can you pull, is there any data from a phone that shows whether it was,
Screen time
you were
records.
engaging, it was engaged at the time?
Screen time records would show that now.
The
It would-
security footage is the best. That's,
Yes.
I mean, that's going to tell us a lot. And that's going to be great evidence in front of a jury, right? Because the jury can see the event. Many times at court, we're having to recreate it to them by telling our version of what happened versus the other person's version of what happened. But if we can watch it on the video, that cuts out a lot of that. That would be an appropriate document request. That would include photos and videos and things like that. Excellent. All right, so the whole purpose of that exercise was just to get you thinking about how discovery works in real life business cases. You have a quiz due Monday on last Thursday, and then this week, all of Unit 3, it will cover the lectures, the lecture outlines, the key terms, the arrow case, and any Easter eggs that might be hidden therein. Any questions for me? All right, so we're going to keep rolling the same format. Next week, we'll start a new topic. All right, y'all have a great weekend. Good job.